humanitarian and compassionate argument. So there is a huge distinction between the two, and we're going to briefly touch upon that. That being said, the main focus of today's meeting or live session is to discuss the PR renewal with H&C grounds. So when you say humanitarian and compassionate arguments, you could also say H&C as the acronym, as the short version. So the first thing is, what are H&C grounds? What are humanitarian and compassionate grounds? And there is a list. When an officer looks at these arguments, pretty much all arguments can be considered. However, there's really about 3 main arguments that the officer likes to read and has a highest chance of approval. And so those 3, which we'll elaborate further, one is employment reasons. Second is and in no order. So just because I'm saying second doesn't mean that's the second best argument. Second is family emergency, or a emergency, specifically family emergency. And the third is in the best interest of the child. So when we're talking about PR card renewal with humanitarian and compassionate arguments, this type of application is only for clients who are already permanent resident, which means you've already applied for permanent residency, you've obtained permanent residency, and you have 5 years to meet the residency obligation, because you have to be in Canada 2 years or 730 days. And for whatever reason, you have not met the residency obligations. So when you don't meet the residency obligation, you can still apply for a renewal on the PR card by making H&C arguments. And so those are the 3 arguments that, based on my experience, have the highest chance of success. So you were not able to meet your residency obligation for employment purposes. Employment reasons kept you away from Canada. A family emergency, or an emergency nonetheless, kept you away from meeting the residency. And it is in the best interest of a child, a minor child, for you to come back to Canada, because, when you have a child, they don't really have a say. Parents take their kids away from Canada, and, they change their life, they go to school overseas, and then it is in the best interest of the child to come back with the family, maybe for educational purposes or just to live in Canada. Those are the 3. When you do an application to Citizenship Immigration Canada, you should, this is not just pertaining to PR with H&C, you should prioritize. Don't make an application with, everything and anything on that matter. You should hone in on what your primary reasons are, and make sure that you bring that to the officer's attention. Common mistakes are where, I've seen in the past where clients put everything and hope that it sticks, and you can lose the officer with that. It might not be taken seriously if you do that, or you could actually raise more concerns for the officer than alleviate some of the concerns. So when you make an H&C application, try to pick 1 or 2. Even if the third one is also applicable to you. A lot of times there's multiple reasons that kept you away from Canada, but attempt to focus on your primary reasons, elaborate on those reasons, and of course you can just mention, the second or the third reason as well, but hone in on the primary reasons. So that's what H&C is. And again, like I stated, these are the 3 primary ones, the 3 main ones that officers look at, that in my experience have been successful. But we've had other situations where it's also been successful. So to get a detailed understanding, if yours doesn't apply with the work or family emergency or best interest of the child, you should contact me. We can talk about it, and then I can say, yes, this is most likely going to work. Now, when we look at making those arguments, you got to look at and explain to the officer almost everything from the beginning. How did you obtain the PR card to begin with? There's a fundamental difference between when you do a federal application, such as an express entry, and you got the PR through that route versus a provincial nominee, let's say. So you got to address that. Hypothetically, if yours was a provincial nominee application, you should aim to tell the officer that you intend to come back to that province, if that's the case. And if you don't intend to go back to that province, you should explain why. And perhaps it was employment again. You tried, you got a provincial nominee approved for British Columbia, you tried to seek employment there, the employment opportunities were not available or readily available, you got a better opportunity back home or in a different country, you seized that opportunity, and despite numerous attempts or your best attempts to come back to the province, you've not been able to do that. Officers are understanding that we all have to put, food on the table, and with that comes an income, and with that comes an employment, some sort of job. And if, despite your best efforts, you were not able to secure employment in Canada, you had to exit. And so that detailed explanation is needed. So start off from the beginning, how you obtained the PR card to begin with, what was your commitment when you got that PR card, and then what happened, what transpired. A lot of my clients now went on a travel, COVID hit, and out of, not their fault at all, flights got delayed or canceled, and they were not able to come back. So that would be considered an emergency, right? So it wasn't necessarily that was their intention, it just played out that way. So whatever argument you're going to make, you should have supplementary documents to support those arguments. So if it's COVID reasoning, you should provide, and I know it might seem common sense, everyone is aware of what's happening during COVID, and flight got canceled and there was no flights coming in and sometimes going out. The officers still want to review the documents. So you almost have to explain COVID to the officer, explain that on this date, Canada was not accepting flights. And on this date, my country was not having any flights exit the country. It may seem common sense to you, and it probably is, but for an immigration officer to review your arguments and your case, they can only make a decision based on the documents you present to them. They're not allowed to think outside the box. So if you don't give them the documents, then they're not allowed to necessarily make a decision on something you didn't present to them. So that's very important, because a lot of times clients come to me and say, well, that's kind of common sense. And everyone knows this, that this is happening in my country. There's a war in Afghanistan. There's a war happening in this side of the world. And I say, yes, I understand, but we can't rely on the officer to use his discretion. We have to present the documents so that it's in front of him or her, and they can make a decision based on the documents presented. So that's a key part when you're making your H&C argument. The other things I just want to kind of pivot, because there's a confusion about an H&C application. And that's different, very, very different. So when you're doing a PR card renewal with H&C Arguments, your H&C arguments are based on residency. I didn't meet my residency obligation because of this reason, and this is my humanitarian and compassionate reason. I'm asking you to be compassionate. When you're making a humanitarian and compassionate application, that's reserved only for applicants who are physically in Canada. And those individuals don't need to have legal status. They could be someone who came as a visitor. They don't have any other options available to them, or they don't think they don't have a good chance to apply for PR. So they're asking an officer to be compassionate despite the fact that they don't have another application to present to them. And that's completely different than what we're discussing today, which is I did get my PR. At one point, I was eligible. I got approved, but I don't meet the residency, and I'm making these H&C arguments. So I hope that distinction is very clear, because I find a lot of clients make that mistake, because if you do, then you're going to find, most likely you're going to go on CIC's website and you're going to read upon H&C application and not the PR with H&C. You're going to make potentially the wrong argument, and worse, you're going to submit the application to the wrong department, because they do sound very similar. That being said, I don't find that there's a lot of information on PR card renewal with H&C grounds. And there's one main reason. Officers don't like to encourage this type of behavior, to that there is an alternative once you don't meet the residency, once you get the PR. So it's not, in my opinion, readily available. There's not a lot of data unless you really dig into the regulation where this application is allowed. The other thing I want to mention is, and this is also a very common misconception, is that if I don't meet my residency, that means I'm no longer permanent, or I don't have a PR card or something like this. So let's focus on this very quickly. It's called permanent for a reason. When something is permanent, it means it's forever, right? So your status is still there. You're still a permanent resident of Canada. You just don't have a permanent resident card. And that's very important to understand. Your status remains permanent. You're still considered a PR. So when you're submitting an application, whether it being to Canada or another country, you're still PR. You're still permanent, but you just don't have the card. Now, the PR cards were implemented after 9/11. This was not the case. It used to be called IM 1000. It was a piece of big paper, and it's permanent. It didn't have an expiration date, for example. But after 9/11, of everything that happened, now the card needs to be renewed. So for you to hop on a plane, that flight attendant or whoever it is that puts you, through the airport, security, they want to see a valid card. And so they're not necessarily knowledgeable enough to understand that just because your card expired doesn't mean your status expired. So if you have an expired card, you won't be able to physically hop on a plane to come to a Canadian border crossing. And so that's important. And so that's why you need to make the H&C arguments to get the new card. So the officer is allowing you another several years to meet the residency obligation. Now, let's say you're an American citizen and you, just as an example, you're a permanent resident of Canada. And so the reason I'm using US as an example is because US is visa exempt. They don't need a visa stamped in their passport to come to Canada. That individual could take their expired PR card, come to a land crossing between US and Canada, and that officer is supposed to let you in. So again, I repeat, let's say you come from a visa exempt country like the US or European country, and you can get yourself to a Canadian land crossing. If you can get yourself to a land crossing, that officer will let you in. The difficulty, though, is you might think, okay, well, that's easy then. I'll just get to a land crossing and then they'll let me in. The difficulty in that situation is that that officer's discretion is that they can issue a Section 44. And so what that means is that that officer says, fine, I will let you in because I have to, but I'm not satisfied. I'm not satisfied that you're abusing the system. You're manipulating the system. You didn't meet the residency, and now you're doing this. You're coming to a land crossing, and I have to let you in. So I'm going to issue a Section 44. And so when that happens, you get an urgent hearing. Usually very soon after, you get a letter to say, now you have to present yourself and your case, and an officer will listen to it. They will make a decision. Then that officer will make a decision on your residency. Yes, you can make H&C arguments at that point, but in my many years of experience, 10 plus years, at that point, it's a bit too late. In my experience, have not seen anyone win when a Section 44 is issued because the officers only strictly focus on, do you have the residency or not? And the answer in your case most likely is going to be, I don't meet the residency. And so, yes, you are able to present the H&C arguments, but you most likely will not win it at this hearing. But if you submit the application, so PR card renewal with the H&C arguments prior to traveling to Canada, then in my experience, and for all the clients I've dealt with, the success rate is quite high. Canada does attempt to the best of their ability to allow you almost like a second chance to meet the residency. But you need to follow the proper steps, submit an application, make the strong documents, the arguments, etc., show genuine intent, and from my experience, it's gone very well for my clients. Some clients who've tried this whole I'll cross to the US and to Canada and I hope it sticks have gone the hearing, and then they contact me and I'd be like, listen, I can represent you, but I think it's money down the drain because chances are you're not going to win it. And if you don't win that hearing, then your PR status can be taken away from you, and usually it is. So then you get a removal order from Canada, you get a deportation order from Canada, your PR card is taken from you, and you are no longer permanent. So up to that point, you were permanent, but you failed on the H&C grounds, and now the officer takes away your status, and that's it. They deport you, and you have to start back from zero. Talk about eligibility, talk about authorization to return to Canada, and it becomes quite messy at that point. So if you have any questions, you could message on that chat box and I can read it and answer. I'll try my best to answer any questions. If I don't, I will get back to you. If you give me an email address, I can definitely address it on an email. So we've addressed, you know, what H&C grounds works, what is H&C, what's the difference between an H&C application versus a PR card renewal with H&C grounds, and who can apply. So just to reiterate, for PR card renewal with H&C arguments, obviously you have to be a PR card holder to be eligible to apply for that. So that's key. With this application, you don't need to worry about police clearances and things like this. Now, a question I'm seeing here is that what if at the time that I had my PR and what if afterwards my child was born outside of Canada and that child is not a PR card? That's a very good question. Happens a lot where obviously you've been out of the country for a long time and you either got married or you got a child and so forth. This is not a family application. This application is assessed individually. So the PR card for you will be assessed. Once the officer assesses that, then you can do a spousal sponsorship, a child sponsorship, or whatever. You cannot, in that PR application that you're stating, I don't meet the residency, consider my H&C grounds, also add a child that immigration didn't know about or a spouse that we didn't know about. So that comes afterwards. So that was a good question. What other requirements are for this application? You don't physically, obviously, have to be in Canada. The whole point of a PR card renewal with H&C arguments is that you're not in Canada. You are outside of Canada. Most likely you're stuck outside of Canada. Your card has expired. There's no way of you coming to Canada. And so we can submit it. You don't physically have to be in Canada because that defeats the whole purpose. If you're in Canada, then you don't need this application. There's a different application you need to apply for. These are for people who don't meet the residency. The other thing I'm going to mention is, because I'm seeing here, when can I apply? It's at any point you can apply for this application. You can apply while your PR card is still valid. You can apply after it expires. And to answer that question more intelligently, I would need to know your situation. I would need to know, how you came to Canada, how many days do you physically have in Canada or you had in Canada, when does your PR card expire, if it's already expired or not, and then I can tell you, if that's going to work or not. But technically, you can apply at any point. You can apply while the card is still valid and you know that you won't meet the residency by the time the PR card expires, or even after. I have several clients that applied several years later. Not recommended, but definitely possible. Because again, the officer looks at your intent. Your card expired 4 years ago, and now you're making the application. Why? Why did you wait 4 years? Is it because you didn't care about the PR card? So these are the questions that the officer is going to ask, and we need to have an answer for that. Why did you wait until your card expired? Why did you wait 4 years after it expired? What did you do? What kind of attempts did you make to come back to Canada, et cetera, et cetera? When this application is submitted, you barely get communication from the officer. Unlike most immigration applications, there's a lot of back and forth. You get the UCI number, you get communication. The officer may ask additional questions, documents, give you some timeline to provide those documents. That is not what happens with a PR with H&C. At best, you get obviously a UCI number, a file number. Once it's submitted, you get a file number to say, yes, it's in process. And then really the final decision. Barely do you get communication of any sort before that decision is made. This is not an application where the officer will help you out and direct you to make the right arguments. You either did it or you didn't. And so that's very, very important. You can submit additional documents throughout the process, but I've never seen an officer request additional documents. They don't sit there and say, okay, why don't you clarify your employment? You didn't provide me these documents, so provide me these documents, which does happen with other applications like spousal and so forth, where an officer requires clarification. So when you do submit it, the idea is it should be very thorough and detailed and submit a good application. And as your situation changes, you can always add additional documents. The processing time is always, when I tell my clients this, they fall off their chair. This is not a regular PR card renewal. When you go on the CIC website and you search how long does it take to renew a PR card, it says, I think 30 days or something. That's obviously not your case. You are not doing a PR card renewal. You are doing a PR card renewal with H&C Arguments. And if you look at the CIC website, there is no drop-down menu that says this is your processing time. So 10 years plus doing this, you're looking at minimum 12 to 18 months of processing. And I know that seems like a lot. It is, but you're not priority. You didn't come to Canada. You don't meet the residency. Canada doesn't prioritize you. So we'll get to you when we get to you. Officers prioritize family reunification and getting you together with your husband and your wife and your child. But we gave you the PR card. We told you to stay 2 years. You didn't. We will read and listen to your arguments as to why you didn't, but we're definitely not going to expedite it. Right. So a lot of clients say, oh, but now I need to come because this is happening and I got a job offer. I need you to expedite it. And I always tell them it's not up to me. And I have not seen, actually, no, in my 10 years, there was one client that got it within 2 months. And I just think she was just a lucky person. All other clients have waited around the 12 to 18 months of processing. And during COVID, some clients have waited even longer. And so you can't really ask expedited processing for that. So to recap, we submit the PR with H&C. We wait for the UCI number, which could take anywhere between 1 to 6 months to get. average it about 4 months. Once you get the file number, you just sit tight and you become patient. In that time, we help our clients to, further enhance their application by, you know, creating more ties to Canada, if that's possible, to show intent of coming to Canada permanently this time. And so each client is different. Some clients can have ample ties created, and some clients cannot because they're not physically in the country. And so again, comes with arguments as to why, despite my best intentions, this is why I cannot create ties. I cannot just buy a house in Canada when I'm not physically there. I cannot open up a bank account if I'm not physically there, et cetera, et cetera. And so once the UCI number is given, we then wait patiently for hopefully the final decision. Assuming your final decision is positive, this is the hardest part for clients to understand. Once the decision is positive, then now you have to come pick up the PR card. And the irony of all of this is that only you can pick up your card, and only you can pick up the card inside Canada. They don't mail it, even though we know that you're not in the country, even though we know that you're stuck outside of the country. The officers still want you to pick it up. And so at that point, we can either try to get you via land crossing to say, hey, we have an approval. I just need to come pick it up. I need to come through a land crossing. That's good. But most of my clients are not that lucky, which comes to the second application. And that's where you most likely need a travel document. And that becomes another ordeal because travel documents are quite delayed now too. You're looking about 8 months of processing, depending on the country you're coming from, for that application, because you need a stamp in your passport. No, you cannot apply for a visitor visa because you are not a visitor to Canada. You're still permanent. We've approved that you're still and will continue to be permanent, so you cannot apply for a visitor visa. You have to apply for a travel document, which we can discuss at a later time about that. But for most clients, there's actually 2 steps. If you don't have the land crossing as an option. Okay, let's see. So I covered H&C grounds. I covered who can apply, the requirements, the processing time, and eligibility to apply. Now we can discuss legal fees. Legal fees really is a question that most clients want to talk about, but it depends on you. It depends on who you hire. I can only talk for my firm, and I'm sure that because this is a live stream, I'm going to post it on YouTube and Facebook and things like that for people who are not able to join. Fees change all the time. Life changes all the time. So what I'm telling you today might not be applicable tomorrow. It's just I'm giving you an average so you understand the magnitude of this application. But that doesn't mean that I haven't done it for less or I haven't done it for more. It really depends on you, the client. But be prepared for most law firms to pay $5,000 plus for this type of application. This is, as you know, as I stated earlier, this is not a simple PR card renewal. You meet the residency, put up a form, a bunch of documents, submit it, and it's like 100% approval. This is, we have to convince the officer. There's arguments to be made. It's a 12 to 18 months processing. It's a lot of work and time. The best part about this is, for my clients that I understand, is they actually like the fact that it's not a quick process. They like the fact that it takes 12 to 18 months because it gives them time to kind of close down their ties where they're coming from. So average legal fees for PR, and that's not necessarily for a family, this is an individual, is around $5,000. A family, you're looking at 5,000 plus, probably, let's say 6,500 is a reasonable number to kind of keep in your head. The government fees, though, is the same. It's just $50 for the card to be renewed. So that you get a little break on, but the legal fees, that would be average. If you do hire a representative, I would highly encourage you to ask a lot of questions and make sure that they understand the distinction between the H&C application and the PR card renewal with H&C Arguments. And they sound similar, but they, like I've stated many times, they are two separate applications, two separate forms, two separate documents. Like it sounds the same, but it's absolutely different applications. So make sure you know almost drill the representative and make sure they understand the two differences. Because you'd be surprised, even representatives have made this mistake, and I'm like, well, you've just simply applied for the wrong application. That's why you got denied. Okay. The last point I'm going to make is ties to Canada. Obviously, the more ties you have to Canada, um, the more you have in Canada, the more you intend to have in Canada, the higher your chances of approval. Um, for me, most of my clients have very limited ties. From my experience, they have, they've stayed at best maybe 3, 4 months in Canada. Most of them, not even that. They came landed and then they kind of had to exit. And so that's fine too. But then there's a storyline that needs to be told to the officer that this is why I did this and this is what I intend to do in the future. And it has to be a believable story. But the more you have, the better. And that could be anything from, having friends here, family, bank accounts, property, a church member that you keep in touch with. Tie is tie. It doesn't matter what it is, so long as you have a connection with Canada. And that's the past connections, what you have maintained your connections, and future connections you intend to make with Canada. So all of those will apply. Okay, so there's also a link if you guys have any further questions regarding this. There is a link that I can share with you guys. You can, contact me. I can assess your matter individually and we can discuss it. But this is almost going to be mostly repeated, and I can answer your specific questions. So I'm going to just be quiet for about a minute, see if you guys have any questions you want to ask me on the chat box before we end the session. Now, I know this session is for longer. That's just because in case you guys have questions, but if there's something I did not address. Okay, so I think everyone is stating that they are okay with it. They will contact me privately with their private situation and questioning. So if there's anything else, know that with Akrami Associates, there's always a way. We're here for you. The phone number and everything is mentioned on the website. So we look forward to hearing from you. Thank you. And until next time.